an appeal in the matter of Tipu and Secretary of State for the Home Department.
Yes, Mr. Manley.
Ladies, my lord, I appear for the appellant this morning with Mr. Maxud, Millernet, and Mr. Bias appears for the Secretary of State.
Yes.
My ladies, my lord, this appeal, as the court knows, raises questions as to the proper construction and effect of Regulation 8.2 of the Immigration European Economic Area Regulations 2016. The regulations transpose into domestic law Citizens' Rights Directive 2004. In broad terms, my ladies and my lord, the scheme allows an extended family member of an EEA national to join them in the UK if the family member is dependent upon the EEA national or is a member of the EEA national's household. There are two questions of law before the court. The first question is whether providing financial support for education can, and if so, when, amount to dependency. Second question is whether a gap in dependency and membership of the same household can, and if so, when, act as a disqualification. I shall seek to persuade my ladies and my lord that the Upper Tribunal erred as to these questions in making its decision. As the court knows, the Upper Tribunal made its decision on an appeal from the Secretary of State's decision to refuse the appellant's application for a residence card as an extended family member. So subject to any observations, what I propose to do this morning is to address you briefly on the law first. I will make some brief submissions on the two questions in turn, focusing on the legal principles. I will then address you as to the facts and the Upper Tribunal's findings and reasons.
Yes. There's no challenge to the findings of primary fact, is there?
No.
And so far as the two grounds are concerned, if you win on ground one, you don't need ground two, do you?
That's right, yes. So the first question, I'll start with issue one, ground one, which concerns financial support for education. So may I start by showing the court the directive and the regulations?
Yes.
And I will then make three short submissions as to their effect. The directive is in the authorities bundle behind tab 1. May I respectfully invite the court to look first at Article 2, which appears at page 7. You'll see that Article 2 provides certain definitions, and the phrase family member is defined at Article 2.2. And you'll see that definition has 4 limbs. If you then look at Article 3, the article that is relevant for the present purpose, you'll see that Article 3.1 concerns union citizens and their family members as defined. So union citizens and their family members have an automatic right of residence. Article 3(2) concerns other or extended family members. Those family members do not have an automatic right of residence, but you'll see that there is an obligation on the member states to facilitate their entry and residence in accordance with the national legislation. And you will then see the two limbs, and the first limb concerns a family member who is a dependent or member of the household of the European Union citizen. And limb 2 concerns the partner. So it's limb 1 that is relevant in this appeal. Now the regulations are behind tab 2. And you'll see that regulation 8(2), which is at page 26, seeks to transpose Article 3(2)(a) of the directive. You'll see from Article 8(1), Regulation 8(1), that an extended family member means a person who is not a family member, but who satisfies a condition. And the relevant condition in Regulation 8(2) is that they are relative of an EEA national and are dependent upon the EEA national or member of their household.
Is relative defined somewhere?
Sorry?
Is the word relative in 8(2)(a) defined?
I think yes, but we do not have that regulation in the bundle. You can certainly provide the court the reference to it following the hearing, but there is the reason why it's not in the bundle, because there is no dispute that the appellant is a relative for the purposes of Regulation 8(2)(a).
If you can just give me the reference, don't have to produce a copy, but
Thank you. We'll just find the precise regulation where you have the
Thank you.
definition, and we'll provide you shortly. So a person can qualify in 4 different ways. There can be prior dependency and present dependency. There can be prior membership of a household and present membership of a household. There can be prior dependency and present membership of a household, or prior membership of a household and present dependency. So these are the relevant regulations. Can I now make 3 short points as to their effect? Now, my first point, my ladies and my lord, concerns the primary objective of Article 3(2) and Regulation 8(2). Now, the purpose of these provisions is to maintain the unity of the family in a broader sense. Now, these provisions are obviously intended for those individuals who are not family members as defined, i.e. spouse, etc. What these what these provisions do in my respective submission is that they seek to extend the relevant benefits to other family members who maintain close and stable family ties with an EEA national. Now, the authority for that proposition, my ladies and my lord, is the judgment of the Court of Justice in Rahman. You have that authority behind tab 10 of the authorities bundle. If you wish to see the questions that were before the court, those questions are set out at paragraph 17 of the judgment. This is at page 166 of the bundle. And you'll see that all 6 questions concerned Article 3.2 of the directive. And they were directed in particular to the issue of dependency. The paragraph that supports the proposition that I've just made is paragraph 32. You'll find that paragraph at page 170 of the bundle. May I respectfully invite the court to read that paragraph, in particular, the last 3 lines. And you will see that the phrase close and stable family ties appears in the 3rd last sentence. So that is the objective of these provisions, the objective that in my submission one must have in mind in considering the precise questions that arise in this appeal.
Paragraph 40 is important as well, isn't it? This was the case that decided that
Yes.
on the meaning of the word facilitate,
Yes.
and that was the case that reinforced the point that although there has to be dependency at the time when you seek entry to the UK, the domestic legislation may impose particular requirements relating to the nature and duration of the dependency.
Yes, no issue with that, lady. Now, my second point concerns the meaning of the phrase dependent as it appears in Article 3.2 and Regulation 8.2. Now, that phrase is not defined in the legislation. You would not find it in the directive or in the regulations. But it has been defined in the case law as provision of material support for essential living needs.
Is the GIA decision still
this
good
is
law?
Precisely, yes.
Yes.
So this is what the Court of Justice said in GIA. If you wish to see that authority, it's behind tab 4 of the authorities bundle. and the paragraph where you will find that conclusion is paragraph 43, which appears at page 71 of the bundle, right at the end of page 71. Now you will see that that paragraph deals with Article 1 of the Directive 73/148, but it's common ground and well settled that what is said there applies with equal cogency to Article 3.2 and the regulations. And you'll see that the words material support in order to meet their essential needs appear just below letter H. So that is the ultimate test, material support for essential living needs.
That is decided on the basis of the evidence on a case-by-case basis.
Yes, no issue with that, yes. Now my third and final point concerns matters that are irrelevant in considering whether there is dependency. Now, a person's ability to find work, make a living, and become self-supporting is irrelevant. If a person cannot support himself from his own resources, it is not permissible for the decision maker to ask why that is the case. The fact that a person chooses not to become self-supporting is of no legal consequence. And the authority for that proposition is this court's judgment in Lim. You have that authority behind tab 5 of the bundle. Well, behind tab 5, you have the immigration appeal report of the judgment. Now, those reports are not available online, and it's quite a task to copy them from the actual law report. So the copy that you have behind tab 5 is not remarkably clear, but I have better copies of the judgment for you. Of course, the approved judgments that were available online. So if there is an issue as to the way in which the authority is copied, may I perhaps just hand up a better copy if that assists? But if not, then...
Well,
Yes.
Speaking for myself, I found the copies in the bundle were illegible. I printed out, slightly grumpily, I printed out new copies from the digital file last night. Small black mark to your support team, Mr. Malik, but it would be quite wrong to hold that against the appellant anyway.
Yes.
I don't know whether my ladies have legible copies now.
Well, my apologies, of course.
It
It's
applied,
ultimately my
applied to this
responsibility.
one and number 6 and number 7.
Fortunately, Mr. Malik, I'm very familiar with this authority, so I'm not
Yes.
worried.
Okay. Anyway, we have it.
So you'll see that the issue that was before the court is one that is identified at the outset at paragraph 1. The question was whether the respondent, who has sufficient savings to meet her own needs but chooses instead to rely on financial support, can be treated as dependent. The answer was no, but the relevant paragraph is paragraph 32, which is the very last paragraph. paragraph 32, which is the second last paragraph of the judgment. So you'll see that this is where Lord Justice Elias made the point that if a person chooses not to become self-sufficient, self-supporting, then that is simply irrelevant. It can be relevant where the Secretary of State seeks to rely on the abuse of rights provisions. But when it comes to a straightforward question of whether there is dependency, that has no legal consequence. Now, with these 3 points in mind, can I now turn to the question of provision of financial support for education? Well, there is no authority on that point. That was a question that this court acknowledged in a case called Singh, but decided not to say much about it. Now, things like food, water, clothing, shelter are things that are required for physical survival. And there can be no doubt that those things are essential living needs. Education is not strictly essential for physical survival in a literal sense. But in my submission, it would be wrong in principle to read the legislation so as to exclude education completely. In my submission, that would be inconsistent with the objective of the legislation. The objective, as it appears from Rahman, is to benefit extended family members who maintain close and stable family ties. Now, one way to maintain close and stable family ties could be for the EEA national to pay for education of the other family member. And no one can dispute that education is important for personal development. It's important for social mobility, and it's important for functioning of society. It helps people acquire knowledge and skills, and it enables them to navigate, pursue their careers, contribute to the economy, and ultimately become self-supporting. And it can have a significant impact on a person's quality of life, opportunities, and ability to make a living. So in principle, my ladies and my lord, there can be no objection or no proper objection to the notion that education can be an essential living need. The real question is when that would be the case. The Secretary of State says, to echo the phrase that my lady used, is that it should be considered on a case-to-case basis. Although I do not have an issue with that in principle, in my respectful submission, to leave things there is likely to result in an unsatisfactory situation. Now, the court, in my submission, must strive to find principles that first instance judges across the country can apply in deciding bulk of these cases. It is not ideal in my respectful submission to simply say that, well, fact-finding judges should decide the issue on a case-to-case basis without giving guidance as to what the exercise would actually entail.
Well, they don't need guidance to find out whether somebody is being maintained for their food and clothing. Why do they need guidance about education?
Well, because it is obvious and uncontroversial that food and clothing is something that is an essential living need. So there's no controversy about it. Now, so far as the education is concerned, it can be an essential living need, and it cannot be an essential living need depending on the facts of a particular case.
Well, I don't think that's disputed, is it?
Yes, I don't have an issue
So
with
what,
that.
What guidance would you be saying,
Yes.
given that it is fact specific,
Yes,
and you accept that education may or may not be
yes.
an essential living need? What are you saying the dividing line should be?
Yes. So, in my respectful submission, one can divide education in three broad categories. First category is school education for children. The second category would be post-school education that a person embarks upon immediately after completing the school education and before they start working and make a living. And the third broad category, in my respective submission, would be post-school education that a person embarks upon after taking a break in order to work and make a living for himself or herself.
Sorry, you don't mean a gap year though, do you?
No, no. A person who becomes self-sufficient, who is no longer dependent, if that person then goes back, then that is another category. So these are, in my respective submission, three broad categories. Now, for category one, in my submission, education will always be an essential living need. So that is school education for children. That is likely to be uncontroversial, but you'll hear from a learned friend.
Up to age 18, I assume you say, or maybe whatever age
Yes.
in relevant jurisdiction.
That's because different school leaving
Children.
ages in different jurisdictions. I mean, suppose that it's compulsory to get education up to the age of 16 in the particular jurisdiction, but you can stay on and do further education to a later age if you wish to progress with your career in a particular way.
Yes.
Is it your submission that if somebody chooses to stay on, that is essential?
Well, milady, that would be category two.
No, it's
And my-
category one. This is school education.
Well-
You can go on to the sixth form, or you can stop at 16. You say essential to the age of 16, yes, but I take it you say essential to the age of 18 because it's school.
Yes, so the submission is that school education for children, a child is someone who is under 18. In my respective submission, will always be an essential living need.
Even if that child could leave school at 16 and go out to work.
Yes.
Bold submission, Mr. Malik.
Well, milady, I have taken you to Lim a minute ago, miladies. I'm familiar with the authority. Now, if a person who can find work but decides not to work and remain self-sufficient and remain dependent is irrelevant.
Yes, but that begs the question of
It's a
whether they're
different
dependent in the first place.
Yeah, LIM doesn't tell you what is an essential living need.
No,
It's about how it's funded.
Yes, I get that. But what I'm seeking to submit with respect, just in answer to the observation that milady made, was that a student's ability, a person's ability to stop studying.
Doesn't stop them being a dependent, but it begs the question.
Yes,
And the point I'm just testing you on, Mr. Malik, is why you say, as a broad brush, it's inevitable that Category 1 any school education will qualify as an essential living need. I'm just pressing you on that because I can see a perfectly viable argument that it wouldn't if school education was only compulsory to a certain age in the relevant jurisdiction.
yes. Now,
See what you mean about compulsory school education?
yes. Now, when I will address you on the facts and will show you the Upper Tribunal's decision, there is one particular paragraph that is directly on that point, and I would be respectfully inviting the court essentially to adopt the reasoning of the Upper Tribunal on that point. The Upper Tribunal, as will become apparent in due course, essentially endorsed the point that that school education for children is an essential living need. And I said, it's unlikely to be uncontroversial. You'll hear from a learned friend, but it's
That was
likely
in
to
the
be
context,
uncontroversial.
if I recall, of the relevant jurisdiction only having primary education as compulsory.
Yes.
You know, our task is to say whether Judge Lindsley's decision in this case was wrong in law. We don't necessarily have to write an essay or give a sort of code as to how the GIA decision should be interpreted.
Well, that of course is entirely a matter for the court. You'll see that in Singh, the court acknowledged the issue, but decided not to say anything about it. And
Some might consider that was rather wise.
yes, but what I'm
You're trying to persuade us not to follow suit.
yes, and I do make submissions that it is time for the court to seek to provide some workable framework for the fact-finding judges to consider the circumstances in which education would be regarded as an essential need. And this is not moot or hypothetical. This is of course relevant to the facts of this particular appeal.
Well, I take it you're moving towards a submission that if you fall into your category 2, then it does amount to an essential living need, irrespective of your motivation for going on to school, to tertiary education immediately after school. But if you just happen to stop and do some work for a few years, you miss out on qualifying for dependency.
Right, yes, of course, you know, Milady has preempted the point that I'm seeking to make.
Well, I guess that, Mr. Malik.
Yeah, so that is category 1. Category 2, I also submit education will be an essential living need. This is where a person completes the school education and then immediately thereafter embarks on higher education.
But you don't need a degree in order to live.
You don't know.
That's the problem.
Yeah.
You may want a degree in order to better yourself, but you don't need it.
Well,
It's not an essential living need, is it? I mean,
yes.
That's the problem I have with this proposition. I put it on the table, Mr. Malik, so that you can facely square it.
Yes. So the way I put it.
Belly face it. Sorry.
Yes.
Sorry. Malapropism. Forgive me.
Now, what I would respectfully invite ladies in law to consider is this: that, well, if education is an essential need, when someone is 17 years and 11 months old, or if it's the age of 16, 15 years and 11 months old, it does not, in my respectful submission, become non-essential as soon as the person turns 18 or 16.
Well, we're considering a case in which the vital period, the period which the Secretary of State disputes, was when your client was 22 to 25.
Yes.
And speaking for myself, the categorization you're proposing seems quite arbitrary. I mean, suppose, for example, that a child in whatever jurisdiction is attending school compulsorily, and suppose that there's no, suppose it's a country where education up to, say, 14 or whatever, is free,
Yes.
compulsory. But the cousin sponsor pays for the child to have private tuition. Is that meeting essential living needs? You would say presumably yes, because the child, let's suppose, is 12 years old. But why is that making a material contribution to essential living needs?
I understand the point with respect, and that really is the reason why I submitted earlier that the three categories were sort of broad categories, and of course there can be a number of other examples falling outside those broad categories, and one example is one that my lord has given.
Not really, because my lord's example is an example of a situation where somebody is contributing finance to someone who is undergoing school education of a compulsory nature, which is enhancing their tuition. And it could be argued that in order to progress, because let's suppose the child has special needs,
Yes.
in order to be able to progress and to pass the exams that are necessary, they need to have a private tutor.
Well, yes. In those circumstances, I respectfully entirely agree that education could arguably be an essential need. Yes.
Don't these examples simply illustrate that it has to be fact specific?
Yes. I mean, I said I have no issue with that it should be fact specific. But the point that I'm respectfully seeking to make is that just to say that it is going to be fact specific without saying more, in my respectful submission, will not be of much assistance to the first instance judges. I mean, that of course would, in my respectful submission, lead to inconsistent and unpredictable decisions.
Is there any indication that there's a problem of this nature going on in the First Tier Tribunal, and that we're getting clashes of views about whether or not certain types of education qualify or not?
Well, Milady, this is of course the second appeal where, on a second appeal, this court has granted permission
Yes.
on this particular question.
Yeah.
Now, well, these appeals, with respect, these sort of appeals will not, in my respectful submission, stop unless the court intervenes and provides some sort of framework.
You think they will stop if the court does?
Well, if the court considers it appropriate to provide some workable framework for judges to consider the question, other than saying that, well, you make your own mind, look at the facts and decide as you wish. These appeals, in my respectful submission, won't stop. And one way to address the problem that was sort of left open in sync by this court is to identify the three broad categories. Now, identifying broad categories is not, in my respectful submission, an alien concept in this jurisdiction. And this is what this court frequently does. Take the example of the issue relating to costs. As the court knows, it's entirely a matter for the first instance judge. It's their discretion. The court has given guidance, identified three categories in which the issue of costs, a framework of three categories by reference to which that issue can be determined by judges. So, in my submission, there's nothing inherently objectionable in the court seeking to provide some framework. And I do respectfully submit that so far as the category 2 is concerned, if there is no break in the education, and I of course recognize that the period in question was when the appellant was 22 to 24 years old. But the point that I'm seeking to make is that if there is no break in the education does not become non-essential as soon as the person turns 18.
Well, isn't that looking at things the wrong way round with respect? The question is whether it continues to be essential. And at the moment, I can't understand why the presence or absence of a break has a bearing on essentiality.
Well, if the education, respectfully submitted, if the education is essential when someone is 16 years and 11 months old, it would be arbitrary in my respectful submission to draw a bright line to say that it becomes
Nothing to do
non-essential.
with the age, it's the nature of the education. Secondary education may be essential in certain circumstances, but why are you saying that tertiary education is essential because there is no gap? It's the absence or presence of a gap that's bothering me.
Okay.
Either tertiary education is an essential need, full stop,
Yes.
in which case a gap doesn't matter.
Now it's
or it may or may not be.
yes. No, I see the difficulty now. But that education, I think, hope it's uncontroversial, can be an essential living need. In my respectful submission, one has to find the appropriate yardstick or appropriate test. And the test that I'm proposing, in my respectful submission, would bring certainty if the court concludes that if there is no gap and the appellant, the person concerned, does not take a break, become self-supporting, and then restart the education, then that, in my submission, would be a principled outcome. Now, if that isn't the test, then what else? I respectfully invite ladies and law to consider what else the court could say, apart from simply saying that, well, you decide cases on a case-to-case basis.
What's wrong with that? You start with regulations, and because of without being too theological about it, because of the role of the Luxembourg court in interpreting EU legislation, it produces a Grand Chamber decision in GIA, and the regulations must be treated as if they read needs material support to meet his essential living needs. Why is it necessary for any further appellate gloss to be put on that? If that's the test. It's been the test since 2007 or 8 or whatever it is. Why is it for us or anybody else to gloss it by introducing categories?
I'm not, with respect, inviting the court to put a gloss on the test. There are things that are obviously essential, said food, clothing, shelter. And then there are things that may be essential, may not be essential. And the classic example is education. Now, education, as said, may be an essential living need. It may not be an essential living need. But if the court leaves things as they are and say nothing more about it, then in my respectful submission, the issue, the real issue that is before the court will remain as it is, as was the case in Singh. I do respectfully submit that it is time for the court to provide some framework, not a gloss on the test, but some framework as to how the decision makers should conduct the exercise in deciding whether education is or isn't essential living need. So very briefly, category 3, this is where there is a gap, a person becomes self-sufficient, and then embarks on an education that I would accept is not would not be an instance where education can be regarded as an essential living need.
Why not?
Yes, may I put it? It's unlikely to be regarded as an essential living need.
I repeat, why not?
Well, because the person because the family member became self-sufficient, took a break, there was no longer a dependency, there's a break in the dependency, and the person then embarks on a university education.
Well, then he ceased to be dependent anyway. And so you don't even get into the question of whether or not the tertiary education is there to provide an essential living need, because on that example, he's been off 3 or 4 years and he's in no sense financially dependent on his sponsor. So good try, but it doesn't really work, does it?
Yes, but I'm not sure with respect whether that causes any difficulty for the proposition that I'm seeking to advance.
Well, it only works if the person concerned was trying to rely on the provision of money towards his tertiary education at the time when he's wanting to come into the jurisdiction as material support for essential living needs, having been self-sufficient previously, I suppose. In theory, they might do that.
Yes.
But it's a fairly unlikely example. And then it would be said, well, you don't need to go to university or get a degree in order to live.
Isn't the difference one of the problems with the difference between your category 2 and 3 is category 3 effectively you're accepting that evidentially the chap
Yes.
or the individual has developed self-sufficiency, so it's very difficult to argue then that going to university is
Yes.
an essential living need. But fundamentally, you can make the same point in relation to category 2, because in both categories, presumably the reason for going to university is to better yourself and perhaps get a better job as a result of it. But the fundamental motivation is the same, likely to be the same in both categories.
Yeah. See, so the submission is that if there is no break, then education will always be essential. If it's a break, then it will not be essential. Entirely accept the point about the underlying motivation, but I do respectfully submit that one has to identify some workable framework, and what I seek to put forward is a principled and workable framework.
You refer in your skeleton to part of a paragraph from the decision of this court in SM India.
Yes.
And what that paragraph says, I quote, "In reality, people's circumstances, their lives and their lifestyles are not always quite so straightforward, and any attempt to draw a bright line between determining whether an applicant has a need for material support to meet his essential needs and where there is recourse to support, it being unnecessary to determine the reasons for that recourse, is best considered not on the basis of hypothetical examples, but on a case-by-case basis with the benefit of clear and sufficient factual findings by the tribunal."
Yeah.
Well, it seems to me that you're saying that's wrong, that there shouldn't be determination on a case-by-case basis with the benefit of factual findings, but that we should give guidance which would presumably be binding on the Home Secretary as to what material contribution is, what essential living needs are, and so on.
Yes, so I see. So the reason why I cited that paragraph, because in my respectful submission, and I'll make that point briefly when I'll show you the Upper Tribunal's decision, it is the Upper Tribunal that was seeking to draw a bright line by essentially saying that as soon as you become an adult, education ceases to be an essential living need. So it is the Upper Tribunal, in my respectful submission, that was seeking to draw a bright line, providing a framework and saying that there are sort of three broad categories. It is not, in my respectful submission, drawing a bright line. It is, in my respectful submission, to address the problem of the Upper Tribunal identifying a bright line to consider the issue.
All right, well, Sean, are you going to take us now to the Upper Tribunal judge's judgment?
Yes, so
Tell us
these are my
what's wrong with
submissions.
it.
Well, so these are my submissions on question 1, ground 1. May I just make brief submissions as to the law on ground 2, and will then address you as to the reasons given by the Upper Tribunal and the findings of fact that are made. I mean, this will avoid duplication of submissions. It's best, in my respectful submission, to look at the Upper Tribunal's decision once you've heard submissions on the law. So unless there is an objection to that approach, may I make very brief submissions on ground 2, legal principles. I'm very grateful. So on ground 2, this concerns the gap, the issue of gap. There are three authorities that I need to address the court on. The first authority, my ladies, my lords, is one that endorses a flexible approach to Regulation 8.2 and Article 3.2. And that authority is the judgment of the Upper Tribunal in the case of Dohu, the authority that the Upper Tribunal cited. Dohu is behind tab 3 of the authorities bundle. And the paragraph, the relevant paragraphs are at page 33 of the bundle. So page 33, you have paragraph 10, which sets out 4 different ways in which a person may qualify. And you'll see that what is said at 11, that it's not necessary to show prior and present connection in the same category, in the same capacity. The Upper Tribunal deals with the meaning of the word continues at paragraph 12, and then makes a general point about the objective of Article 3.2. And you'll see that the sort of the fundamental point that is made at paragraph 13 is that one must have regard to the objective of the provision, and the provisions are sort of sufficiently flexible in allowing a person to qualify in four different ways. So
Yes.
this is the authority for that proposition. It's fairly flexible, and a sort of literal reading wouldn't be appropriate.
Well, I don't think anybody quarrels with the proposition of the 4 categories.
Yes.
But there still has to be continuity between category 1 and category 2 if you're moving categories.
Yes, and what that actually means is an issue in this case.
Yeah.
Now, the second authority, this is the authority that the Upper Tribunal cited in support of its analysis as to what continuity entails, is this court's judgment in Chowdhury.
Yes.
You have that behind tab 8 of the authorities bundle. Now, may I take, ladies and lords, to page 114 of the bundle, just to highlight the particular facts of that case. This is paragraph 12. So you'll see paragraph 12, page 114, that the applicant in that case was part of the sponsor's household in Bangladesh until their departure for the UK. But if you look at the text that appears between E and F, you'll see that there was no evidence of any financial support. So there was no financial support whatsoever, or other dependency between 2011 to 2014 and 2015. So no evidence of financial support. And you'll then see that both the applicant in that case and the sponsor were silent as to what the appellant was doing over those years. Now, if you then go to paragraph 27, where the court deals directly with the words "and continues to be," and you'll see that those words, when considered in the chronological context, contemplate persisting state of affairs. So persisting state of affairs is one that, in my respectful submission, one must look for. And then paragraph 29. So this is where the applicant sought to rely on what was said in Rahman, the provision that I showed you. And you'll see that the court picked the word stable. This is right at the end of page 117, and said that contemplates a durable condition or a state of affairs. So persistent or durable state of affairs is what is meant by continuity.
Not an intermittent one, separated
Yes.
by a period of time other than could reasonably be adjudicated to be de minimis.
Yes, absolutely.
That's binding on us.
Absolutely. Persistent and durable. And finally, if you look at paragraph 30, which appears on the next page, last sentence of paragraph 30, you'll see that, and that really was the reason why the appeal failed on the facts. The appellant was not financially or physically dependent upon his great uncle between 2011 and 2014-15. And the nature of their contact is not evidenced. Of course, this is binding, but those were the facts. So this is an authority, in my respectful submission, for the proposition that the decision makers should consider in deciding whether there is continuity, whether there is a persisting or durable state of affairs as to dependency and or membership of the same household.
But that means dependency within the GEA definition, doesn't it?
Well, the submission that I make with respect is that that means the state of affairs would not be persisting or durable if there is no financial support or other dependency, or where the nature of the contact between the family member and the EEA national is not evidenced. Now, these are the words that the court used in the two paragraphs that I've taken you to.
That was in relation to the facts of that particular case, but it's very clear from Chowdhury what is meant by continuity. And as my lord says, there's got to be a continuity of dependency in the Gia sense before you become a member of the household, or vice versa.
Lady, if I accept that observation, I suspect that that would be the end of the appeal on ground 2.
It would,
Yes.
and it probably is,
Yes.
because I can't see a way around it, Mr. Malik.
Yes, lady, I have. You have my submission. I've taken you to the two paragraphs
Yes.
where
Yes.
the court said essentially that one must be looking for a persisting or durable state of affairs, and used the words that what had happened in that case was there was no financial support or other dependency. That is how I respectfully invite my ladies and my lords to read that judgment.
So are you submitting that financial support which is short of dependency would qualify on this reading?
Well, the court did not say, in my respectful submission, that financial support short of dependency would act as a disqualification. That is not what, in my respectful submission, the court said.
And the meaning of the word other?
No financial support or other
Other
dependency. So no financial support or other dependency.
And doesn't that presuppose that the financial support is dependent financial support?
Well, if this is what was intended, then the court would have said so in the paragraphs to which I've taken you to. But what they essentially said is that there was no financial support or other dependency. The court could have said that, well, it is only dependency in the GR sense, but did not say so. So this, in my...
But the court was interpreting Regulation 8.2, and we know how dependency has been interpreted
Yes.
by the European Court. And it's clear that in paragraph 29, which is the paragraph that sets out all the principles,
Yeah.
that's a consideration of Regulation 8.2.
Yes. So what the decision maker ought to look at is whether there is persisting or durable state of affairs. And we know that the objective is to facilitate those other family members who maintain close and stable ties with the European national. Now, in considering...
But that could mean anything. Could mean emotional ties. It could, I mean, would it have made any difference in Chowdhury if the sponsor during the, I think it was a 3-year gap, wasn't it, had sent the applicant £20 each year as a birthday present? That maintains the family ties in the loose sense, but you couldn't possibly say that the recipient of the birthday presents was dependent during that period.
Well, if it's only £20 as a birthday present, then yes, I would accept that, yes. But if there is more than that, then arguably not. But this the ultimate submission is that this is not an authority for the proposition that if there is, it's not an authority for the proposition that that one must demonstrate financial dependency or membership of the same household on each and every day of the period in question.
Oh, well,
One has to.
there's a specific carve out for a gap which might be logically regarded as de minimis.
Yes.
But by no stretch of the imagination can a gap of several months or a year be regarded as de minimis.
No, certainly not. But it is possible, in my respectful submission, for a decision maker to look at the things globally and take a view that there was financial support for essential living needs, say for a period of 15 years. And out of those 15 years, for a month or two, the financial support was not at the same level, but there was continuity of some financial support. And in those circumstances, to conclude that there is a persisting or stable state of affairs. And that is this case.
What do you say about the decision in Sorab?
Yes, so that is the final authority that I need the court to look at. This is behind tab 9 of the authorities bundle. Now, if you look at, can I just take, ladies and lords, to paragraph 12 of the judgment. This is page 125. Now you'll see that there was a finding of fact that the witnesses' evidence was merely an unsupported assertion, and the judge found that once they arrived in the UK, the appellants, they were not dependents upon the sponsor. Now that was the reason why that appeal failed. And if you look at paragraph 13, in particular the quotation at paragraph 13, you'll see that there were more fundamental problems for the appellant. You'll see that there is a finding that the sponsor was not a qualified person. Second, the appellant had not shown that he was an adopted son. And those were the reasons why the appeal failed. Now within that decision, this is paragraphs 21 to 25, the Upper Tribunal looked at Dohu and Rahman and Chaudhry. Now, of course, this court, in my respective submission, can form its own mind as to what Chaudhry actually holds. But what the Upper Tribunal has said, in my respective submission, is arbiter. It's not binding. It's not binding on the court. So it's Chaudhry that, in my respective submission, this court should be looking at and decide what it actually holds, as opposed to what the Upper Tribunal has said in Sorab, which simply quotes from Chaudhry. Now, these are my submissions on law. Can I now address you very briefly as to the facts and the decisions made below? Now, the Upper Tribunal's decision is at page 40 of the core bundle. Now, as the court would know, there was an earlier decision of the First Tier Tribunal. There's no need for the court to look at that decision because it was set aside as being wrong in law. There's also an earlier error of law decision. There's no need for the court to look at that decision. So this essentially is the remade decision.
You appeared on the error of law decision, but not the substantive one.
No.
Right.
Paragraph 4. this is where the judge records the evidence. Four witnesses gave evidence. Now, if just for the purpose of note taking, if you wish to see the appellant's witness statement and the sponsor's witness statement, those statements are at page 24 and page 33 of the supplementary bundle. And if you wish to, those are quite lengthy witness statements. And if you wish to see the evidence that was before the Upper Tribunal, that the Upper Tribunal accepted, it is in the appellant's witness statement at paragraphs 3 to 8 and paragraph 16. The relevant evidence in the sponsor's witness statement is at paragraphs 3 to 8 and paragraph 17. Now, if you look at paragraph 4 of the judge's decision, you'll see that the judge there records the appellant's evidence, and you'll see that you'll find the reasons as to why the sponsor chose to pay for the education. This is the middle of paragraph 4, because the appellant was a good and dedicated student, and his parents could not afford to support him continuing his education as they were very poor. So, good and dedicated student. He explained in his witness statements as to why education was important, particularly important for him. Now, you'll see that the sponsor gave money for education, school fee, uniform, books, stationery, and travel costs, and tutor fees. And he continued his education, completing his secondary education and starting university. So throughout the school, up until the university, the sponsor was providing support. Then if you look at paragraph 6, now this is important, in particular in relation to the second ground, the question of gap. Now this is where, well, this paragraph falls within the period of gap. And you'll see what was happening during that period. Second sentence of paragraph 6. His sponsor still sent him money for his education. This is the gap period. And other expenses, such as travel, books, clothing, and some food. But accommodation was provided by someone else. So his evidence, it's important to emphasize, wasn't simply that the sponsor was paying for education alone during the period of gap. His evidence was that the sponsor was also paying for clothing and food. There can be no doubt in my respective submission that clothing and food are essential living needs. If you then look at paragraph 12 of the judgment,
Yes.
Yes, paragraph 12 of the judgment. This is where the judge records the sponsor's evidence. The sponsor's evidence was that he provided support for essential needs to the appellant since he was 14 years old in the year 2001. And he then explains why he paid for the education on the next page, because the appellant was a bright student and he knew that the appellant would have had to give up the education if he had not stepped in. Later in that paragraph, this is the second last sentence, he provided money for the secondary and university education, and that included associated expenses. there is no gap. Look at paragraph 13, last sentence. The appellant applied to come to the UK as a student in 2010 because he needed to get to a certain level before that was possible. And then paragraph 14, when the appellant moved to the UK in March 2011, he started living in the sponsor's household. So that was the evidence before the judge. Can I then show you the relevant findings? The first finding appears at paragraph 24. Paragraph 24, you'll see that the judge found that the totality of the evidence showed that the appellant had lived with the sponsor from his entry to the UK.
The 2022 is an obvious typo, isn't it?
Yes.
I think it should be 2011.
2011, yes. Yes. So there is that finding. Now, if you then go to page 47, you'll see the heading conclusions, remaking. Paragraph 28, you'll see that the judge makes a finding that the evidence given by the witnesses was credible on the core aspects of ... provisions of financial support to the appellant by Mr. Salim Ahmed. The judge says that the evidence is credible. Now that evidence, I do respectfully emphasize, included the evidence that is set out at paragraph 6, namely that during the gap in question, the sponsor was paying not only for the education, but also for clothing and food. The judge accepts that evidence. Then paragraph 29, the judge again says that all that witnesses were credible. This is line 4 of paragraph 29, that there was evidence that the sponsor provided funds to the appellant from the year 2000 to 2011. So up until the point when he came to the UK, it was the sponsor who was providing funds to the appellant to enable him to continue his education. The judge, paragraph 30, considers the question as to whether financial support for education was an essential living need. And there is that paragraph that deals with the position of children. That's paragraph 30 and paragraph 31. So what the judge says is that providing financial support to enable a child to study is an essential living need. The judge accepts that, and I respectfully invite the court to endorse that conclusion and proceed on that basis. The paragraph that I respectfully take issue with is paragraph 32.
Yeah.
Now this is where, in my respectful submission, it is the judge who seeks to draw a bright line. The judge says that, well, as soon as that education was essential until the secondary stage and at the point when the appellant ceased to be a child and became an adult. Now this bright line, in my respectful submission, is not a proper way of deciding whether education was or wasn't an essential need. As said, if education was essential when the appellant was 17 years and 11 months old, it does not automatically become non-essential when he turns 18.
When did he complete secondary education? Was it,
It's not very clear, is it?
not,
Well, that's what the judge says. She says, I wasn't provided with any proper timeline.
Yeah. But what the judge says, well, on completion of secondary education and at the point when the appellant ceased to be a child and became an adult. So the judge is saying, in my respective submission, that it stopped to be an essential need when those two things happened when the appellant became an adult.
In his particular case.
In that, yeah, yes. But that, in my submission, is drawing a bright line, and that is in my respective submission a flawed approach.
well, it's only a flawed approach if there's a rule or at least a strong presumption that university education, the cost of university education is an essential living need.
Yes, but at least in the first sentence of that paragraph, the judge is not using the university education as a threshold or yardstick. The yardstick that the judge is using is the age of the appellant.
It's
He
both.
becomes an adult.
It's both.
Combination.
Yes, secondary education and
It didn't
not
continue
alone.
to be essential after the completion of the secondary stage, i.e. when it gets to the tertiary stage, and at the point when the appellant ceased to be a child and became an adult.
Yes.
Well, the two coincide, but she was willing to accept in principle that because of the rights of children to access to education, if you provide the financial support that is the difference between being able to attend a school and not attend a school, that is essential. You can see why she does that. But once you get to the completion of the secondary stage, she says, in this case, it's not good enough.
Yes, and okay, may I just invite my lady to see the real reason for that conclusion.
Yes. Later in the paragraph, I find he'd passed the point when his essential living needs included education whilst in Bangladesh. At least at the point when he entered university education, I find that at this point his education ceased to be an essential living need.
Yes, so I accept that is the finding, but why the judge makes that finding is relevant, and the reasons are set out in the next 3 sentences. And the judge explains, and this with respect is, in my submission, the test that the judge has applied. It's the 5th last line at paragraph 32. At this point, this is when he becomes an adult, reaches the university. In his own estimation, he had sufficient educational skills to travel and work internationally. So the judge says that, well, it's proper to draw the line there, because when the appellant became an adult, he went to the university. He had sufficient skills to travel and work. Well, this approach, in my respective submission, does not sit comfortably with what this court said in Lim. In Lim, the court said that a person's ability to find work and get a job is not relevant. So if it is not relevant, yes.
Thanks, Mr. Malik. Completely different. It's not. You can't say X is not dependent on Y because X could go out and get a job. If there is evidence that Y is giving lots of money to X to enable X to buy food and clothes. But once you take away the giving the money to X to buy food and clothes out of the equation, let's and I know what you say about the evidence in this case, but let's just put that to one side for a moment. then when you're looking at dependents, all that the judge is saying is, well, you don't need a degree. It's not essential. It's nice, but it's not essential, particularly if you can work without it and you've got enough educational skills to be able to work without it.
And I respectfully invite my lady to read that paragraph in a different way.
Yes.
The judge, with respect, is not saying that you don't need a degree. The judge is saying that, well, you are now old enough to travel and work.
No, isn't he drawing attention to the fact that the applicant himself sought a working holiday
Yes.
visa, which
But-
is the applicant effectively
Yes.
accepting that he doesn't need more education.
This with respect is a limb point, and I do invite my lady to look at it. The submission is that the fact is that the appellant did not find work. He did not travel to the UK as a working holiday maker. There was no change in his circumstances.
Indeed, but isn't the point that applying for it rather supports education not being essential? And as my lady says, Lim is getting at a different point, which is the resources, the source of the funds, if you like, as opposed to what is or is not an essential living need.
Well, yes, lady, but if in that context, the ability to find work and become self-supporting is not relevant, in my submission, it is difficult to see why the ability to travel and find work in this context would be relevant. So the submission that I make, the ultimate submission is that the appellant's ability to travel and find work was not a relevant consideration.
Okay, so the judge was wrong, you say, to have regard to that.
Yes. And lim here applies by analogy. And then just finally, paragraph 33, this is where the judge deals with the issue of gap. Now, I'll assume that the court rejects every single submission that I've made and concludes that education was not an essential living need from 2008 to 2011. The judge says that the appellant is disqualified because of that gap at paragraph 33. And there is only that gap. And the judge says that there is a gap of 3 years, and on Chaudhry, the appellant wouldn't succeed. Now, during the gap in question, unlike Chaudhry, there is absolutely no doubt that the sponsor was providing financial support to the appellant. The evidence is clear. The Upper Tribunal makes that finding. So financial support, unlike Chaudhry, was being provided. And we know from paragraph 6 of the judge's decision, the paragraph that I've shown you, that financial support was provided not only for education, but also for clothing and food. Well, that, on any view, in my respective submission, was support for essential living need. And this isn't a case where there is a gap in the sense identified by this court in Chaudhry. I do respectfully invite the court to look at things as they are in real world on the findings of fact that the Upper Tribunal has made.
The trouble is that paragraph 33 finds as a fact that there was a gap between the time when he was dependent for his essential living needs. So even during that 3-year period, the tribunal judge has found on the evidence that whatever the support may have been, financial support, for even if it included some payments towards food and clothing, it wasn't enough to show dependency. We can't go behind that.
Well, lady, I have shown you the evidence that was before the judge, and I've also shown you the paragraphs where the judge accepts that evidence, where the judge says that witnesses are credible. Now, if the judge is accepting that witnesses are credible, and during the period of gap, financial support was provided not only for education but also for food and clothing, then in my respectful submission, there isn't a gap. I'm not asking the court to go beyond the findings of fact made by the tribunal.
You have to say that paragraph 33 is a perverse decision if you want to do that, because the judge has found there is a gap between dependency.
Yes,
The time when he was a dependent and the point at which he became the membership of the household. She's found that as a fact, notwithstanding that she's accepted that during that 3-year period there was money provided for some money, she doesn't say how much, provided towards food and clothing. That seems to me to be a value judgment that whatever the amount of money was, it wasn't sufficient to show dependency.
well, the judge, with respect, does not say that.
It's an inference. I can't see how you can draw any other inference from paragraph 33, Mr. Malik. And unless you're going to say to us that having accepted the factual evidence, that finding is perverse or irrational, I don't see how we can go behind it.
In relation to food, you have to read it in the last sentence of 29.
A minimal amount.
Yes. Yes. Now whether well, the judge, in my submission, is not making a finding in that particular paragraph that paying for food and clothing was not a support for essential living need.
But if you're construing paragraph 6 very strictly, the only figure given by the appellant is that Salim Ahmed sent him about £250 every 2 or 3 months for his educational expenses. And there's no finding as to how much the contribution towards food was, except that, as my lady has pointed out, that there's a finding of 29, the sponsor only paid the minimum amount of food, mainly the food paid for food. And the judge doesn't appear to have been given any figures for clothing or travel or books, insofar as that's separate from education and other expenses. It was for the appellant to produce evidence to show that the sponsor during this period was making material contribution.
Yes, I mean, the judge, with respect, could have said that. The judge could have said that, well, the appellants and the sponsor have not provided adequate, sufficient evidence. They have not provided the breakdown, and therefore I do not accept that there was any material financial support. But what the judge is saying is that all 4 witnesses were credible, their evidence was credible, and the judge would accept their evidence. And the judge effectively took the view that Chowdhury and Sorab compels the judge to dismiss the appeal on the basis of that gap in the circumstances where, as I seek to persuade the court, there wasn't a gap in the sense identified in Chowdhury. I do ask the court to look at the findings globally. And we are now in 2025. The Upper Tribunal made its decision in 2023. It's uncontroversial. The Upper Tribunal found that that from 2000, from the year 2000, up until now, up until 2023, it's a period of 23 years, the appellant was supported by the sponsor or was a member of his household. The support was for essential living need for all but 3 years on the Upper Tribunal's own findings of fact. Now, if one looks at the case in the way contemplated in Rahman, the findings do demonstrate a close and stable family ties. And to use the words used in Chowdhury, this is a case where on the findings there is a persisting or durable state of affairs. And this isn't a case where the gap, as the Upper Tribunal puts it, acts as a disqualification. And on the findings of fact that the Upper Tribunal made, the findings that I do not seek to challenge, this is a case where the requirement in Regulation 8.2 is met. I'm very, very grateful for the patience. So unless I can assist you any further, these are my submissions.
We're very grateful to you, Mr. Malik.
Thank
Mr. Maxood?
Thank you.
Yes, Mr. Faris.
My ladies, my lord, I can be somewhat shorter than my learned friend. He's covered a lot of the ground.
Yeah.
My intention was to start with the Upper Tribunal's determination. I just would like to make a few points on the law before I do so, just in response to my learned friend's submissions. Unsurprisingly, much of what my learned friend has said on the law is agreed. They're well-established positions, but there are some points of disagreement that I need to address. First of all, my learned friend dealt with the objectives of the directive and the objectives of Article 3 of the directive, and you were taken in that regard to paragraph 32 of Rahman, where the Grand Chamber in that decision said that the objective of that provision, Article 3.2, is to maintain family unity in a broader sense. The objectives of the directive, though, the principal objective of the directive, of course, is to facilitate free movement of union citizens and their family members. And this was a matter that was considered in Chowdhury. And a similar submission was made about the importance of family reunification in Chowdhury. And the court dealt with that in the context, and I can pick up another point when dealing with this. Chowdhury, you've already been taken to, was of course concerned with the proper interpretation of Regulation 8, whether or not there needs to be a continuing state of dependency. And I say that was the finding in that court, in that judgment. But what the court first of all established was that, of course, because extended family members, Article 3.2, was concerned with a matter of national law, they had to first of all decide as a matter of national law what our Regulation 8 of the 2016 regulations meant. And that is what the court did in the run of passages between paragraphs 25 to 30. We were taken to paragraph 27, where the court set out its conclusions effectively, that what there needs to be is a continuing state of affairs. But in my submission, it's very plain that what the court was referring to was a situation of understanding what there needs to be in terms of continuity, in terms of ongoing dependency. And you see that from paragraph 25, the reference there to the court has previously assumed the need for ongoing dependency. And you also see it when the court goes on to consider in the alternative what the position from paragraph 31 and forward, what the position would have been as a matter of EU law. And I'm blending my points here because there's a point here about the objectives of the directive, but there's also a point here about what the court was doing in terms of its judgment. If you follow these passages through, you see that at paragraph 34, Mr. De Mello had argued that the 2006 regulations must be interpreted with the objectives of the directive in mind. And then you see what those objectives were at 35. And the court emphasises the point I've made. The primary objective is the facilitation of free movement, with matters such as the reunification of family something as a corollary to that. Important, but a corollary to that principal objective. And reference and reliance was made in Chowdhury on paragraph 32 of Rahman, just as my learned friend makes that here. And you can see from paragraph 39 that the court addresses that. And I do not find that Mr. De Mello's submissions to adequately engage with the judgment in Rahman in the context of the circumstances of that case. In that he relies on paragraphs 32 and 38, it is to highlight the point that the objective is to maintain the unity of the family in a broader sense, the point made by my learned friend, and that the dependence is genuine and stable. However, read as a whole, paragraph 32 defines a dependent as one who nevertheless maintain close and stable family ties with a union citizen on account of specific factual circumstances such as economic dependence. So yes, so far as Article 3 is concerned, there is an objective and a concern in relation to maintaining family unity and genuine and stable family relationships. But no, that is not the end of it. What is important under Article 3 is that maintaining of some element of dependency. And again, just to bring home the point that the court was very clearly concerned in paragraph 27 with a case of continuing dependency. You see paragraph 40, I don't interpret this to engage the possibility of an intermittent dependency. The court very clearly concerned in my submission with a state of affairs where dependency is ongoing, not some level of financial support or family tie which is less than dependency persisting. And that's the point that the court made to my learned friend, and he said in terms of, if I accept that I accept that ground 2 must fail, and effectively that's my submission. So far as ground 2 is concerned.
Yes.
My learned friend also made the submission that's necessary for this court to put in place guidance or a code of some kind in relation to when it is that education could be or should be treated as a matter going to an essential material contribution to an essential need. And my lord referred to the case of SM India and the passage that my learned friend quoted in his skeleton argument. And I endorse that. And the court, when it goes back to the judgment there, the passage above, the paragraphs above that, you'll see that exactly what was being invited, in fact, exactly what was being requested in that case, which is what was being requested here, which is for the court to provide some guidance about a particular scenario relating to the application of the dependency test. And what was being sought in that case was guidance in relation to when abusive rights might be taking place. So when a person was deliberately choosing not to work or deliberately choosing to divest themselves of assets, whether the court would provide guidance. And the court declined in that case. And you have the passage from SM India, which the court has already seen. And I endorse that approach. In my submission, it's entirely inappropriate for this court to provide guidance. There is no need for it. In fact, it risks creating problems that are of unintended consequences, as it were. I endorse the approach that the court took in SM India.
I take it that it's not your position, it's not the Secretary of State's position that tertiary education can never amount or payment for tertiary education can never amount to a matter of financial or economic dependency. It all depends on a case-by-case basis.
My lady, yes. Yeah, my lady, yes. That's exactly the Secretary of State's case, and the Secretary of State says that the Upper Tribunal didn't come at this with any presumption, but made a fact-specific finding. And with those in mind, then I'll go on to look at the Upper Tribunal's determination. I summarise the factual findings in my skeleton argument, but in my submission, what it boiled down to was this. In order for the appellant to establish the necessary dependency, he was required to establish that the support he had received for his education amounted to a material contribution to his essential living needs up to 2011. That's where the tribunal effectively got to, based on its other findings, and that's why there was such a focus on that element of the appellant's case. And the reason that you get there, my learned friend took you to the point that it's accepted that he was a member of the sponsor's household from 2011. So it was the period prior to that that was important. The Secretary of State doesn't take issue with the changing of elements of dependency. That's properly established. But the determination, as we saw in exchanges with my learned friend, was very clearly to the effect that there wasn't material support given for accommodation costs and food. And the court has already alighted on the end of paragraph 29, where that is made clear. There are two periods to consider, and that's important when considered in light of my learned friend's reliance on paragraph 6. The first period is between 2008, at least 2008, and March 2010, because in that period, what the tribunal found was that accommodation costs, food, essential living needs were being covered by the appellant's parents, save for education. You can see that halfway between the two hole punches, he didn't need to pay for accommodation costs or food when the appellant lived with his parents in Bangladesh, as they could provide these things.
Paragraph you looked at?
My lady, paragraph 29 on page 48 of the bundle.
Yeah.
About halfway between the two hole punches, he didn't need to pay for accommodation costs or food when the appellant lived with his parents in Bangladesh. And then the court has already alighted on the point about what happened after 2010 when the appellant came to the UK. The sponsor paid only a minimal amount for the appellant's food. The majority was paid by his uncle, effectively. And that needs to be read in light of paragraph 6 and also paragraph 33. But my learned friend places some weight on paragraph 6, but it's clear that what that was concerned with was the period after the appellant came to the UK. Paragraph 6 is the appellant's evidence is that when he came to the UK for the first year, he went to live with his uncle. His sponsor still sent him money, and that's where you see the reference to clothing. But in any event, that all has to be read with paragraph 33, and the tribunal's finding it's a valuable assessment based on the evidence it had that between 2008 and 2011, the sponsor wasn't providing for his essential living needs. And it's for that reason that I say, or for those reasons that I say, the proper focus of the Upper Tribunal was upon education, was upon whether education could constitute an essential living need or not. The Tribunal directed itself at paragraph 27 to the legal framework. And notably, so far as this is concerned, there was express reference below the second hole punch, the last 5 or 6 lines, to this court's decision in Singh.
Where's that, Mr. Price?
Paragraph 27, page 47, my lord.
Yes, thank you.
And there was an entirely correct summation of Singh in those lines. Singh didn't determine that education was an essential need, but found that it was in principle capable of being an essential need. It was indicated that there would need to be a wide-ranging examination to determine whether education amounted to an essential living need in any particular case. And my learned friend doesn't take any issue with the direction that the tribunal gave to itself, and quite properly in my submission, because it's entirely correct. And just for completeness, the tribunal was obviously plainly alive to the authorities relating to a break in dependency. And you can see that from just above the second hole punch, the sentence before GIA. There must not be a break in dependence or household membership from the country of origin to the UK other than a de minimis interruption. And then the relevant authorities for completeness are set out at the end of paragraph 33, 2 pages on page 49.
Children.
So the tribunal cleared the decks in its own mind, as it were, as to what its focus was upon, which was education, gave itself an entirely correct direction about what it was embarking upon in terms of the legal framework, including the need to undertake a fact-sensitive assessment about education, and then did so. And you see it did so at paragraphs 30 to 32. My learned friend takes no issue with paragraphs 30 and 31. You see in paragraph 30, that's the tribunal making the point that it hadn't been given any considered help on how it was to approach its task, but it had reviewed relevant international instruments, had taken the point from those that primary education at least, and education to some other levels were important in international instruments. Then at 31, it's very clear that it wasn't just the fact that the child was a minor, that the appellant was a minor, that the tribunal relied upon to reach a finding in this case that secondary education, support for secondary education was an essential need. The second line of paragraph 31, I conclude, given the weight given in international law to the right for a child to access education and the context of the evidence before me, namely the very poor living chances and that the appellant would have had aged 14 years, meant that education should be seen as an essential living need. So the essential point is summarised at the end of this paragraph. The appellant didn't have an option, such as some might have had, whereby he could have provided an adequate future for himself beyond mere abject poverty without at least a basic secondary education. So that's a fact-specific finding having regard to the context of this case, where the judge said secondary education for this individual was particularly important. His family were subsistence farmers. Education, a secondary education, took him beyond that. And that vein, that theme is continued in paragraph 32 when it comes to talking about tertiary education. And I don't accept that my learner friend's reliance upon limb is correct. With respect, the way the court put it is exactly how I see the court's analysis in paragraph 32. My learned friend relies in particular upon, or raises a concern in particular about the appellant's, the tribunal's finding that the appellant's own estimation was that he had sufficient educational skills to travel and work internationally. That, in my submission, is simply a reflection of the tribunal's assessment that by the end of his secondary education, he was equipped with sufficient skills to take him beyond where he was, where he started from. And it was for that reason that the tribunal drew a distinction between secondary and tertiary education. And the fact that
do we know when he left school in Bangladesh and went to university in Bangladesh?
My lord, we do not. What we do know...
I think we can take judicial knowledge of the fact that it's very unusual in any country for people still to be at school at age 22. But and there is a finding that he started a university course in Bangladesh.
My lord, if you go to page 41 of the bundle, paragraph 5,
Page 41, paragraph
5. So this is in the run of paragraphs in the tribunal's determination where it's summarising the evidence and the oral evidence given by the appellant. And what is said there is, after the appellant started university in Bangladesh, it was an option to travel abroad. He applied firstly for a working holiday maker visa to come to the UK in 2008, and this was refused. The tribunal didn't have a timeline.
2008.
yes.
Forgive me, my lady, I missed that.
That means that he was at university sometime before 2008.
My lady, yes. And the tribunal, as you observed, didn't have a timeline about the appellant's education. It did have his evidence that he had started university at least by the time he felt capable of applying for a working holiday visa. And so it determined that the gap was at least, didn't use those words at least, but it's clear, I think, from the way the judgment is drafted, that the tribunal took the view that I will consider there to be a gap from at least 2008 to 2011. It's apparent it could have been longer on the tribunal finding. But it wasn't necessary for the tribunal to interrogate that or find that out, because if a 3-year gap is not de minimis, then a 4 or 5 year gap is not going to be de minimis either. Or will we do? So that is why we see, I think, in my submission, the reference in paragraph 32 to not being provided a proper timeline. But what we do see is a very clear finding in my submission that it was secondary education that was important to this particular appellant. At the point that he commenced tertiary education, the evidence that the tribunal had relating to him feeling capable enough to apply to work and travel overseas, capable enough to study overseas, meant that effectively he'd been lifted out of where he started from, and tertiary education was no longer an essential. Tertiary education was not an essential living need for him in his particular circumstances. And so there is not in my submission, any bright line applied by the tribunal to a cut-off, nor is there any assumption made that moving into tertiary education must in all cases disentitle somebody from being considered to be dependent. What there is a fact-specific finding following a correct self-direction of the law. And those effectively are my submissions on ground one. Bless you, my lady. So far as ground two is concerned, my learned friend accepts that his ground two is premised upon failure on ground one. So his ground two is premised upon the appellant not being a dependent or not being in a relationship of dependency for the purposes of Regulation 8, but he nonetheless admits that the level of support, the non-dependent level of support that he was giving should nonetheless entitle him or entitle this court to ignore that gap and conclude that he's been in a stable and continuous state of dependency. And in my submission, it's simply wrong. It doesn't stand
in the face of Chowdhury.
It doesn't stand in the face of Chowdhury, yes. And those are my submissions on ground two.
Thank you very much.
Thank you very much.
Alec, obviously no need to repeat, but if you wish to respond, then do.
Yes, three very short points. The first point concerns a question that my lord asked when I was making my submissions in opening, as to whether there is a definition of the word relative in the regulation. Well, there is, I'm afraid, no definition of that word in the legislation.
I'm glad I remembered that correctly.
Yeah. So there is in Regulation 7, a relative is defined as a direct relative in the appellant's ascending line or that of the appellant's spouse or civil partner. But that provision applies only to family members, not to extended family members. So the position is that the legislation does not limit relative to a particular type of relative. So there is no exclusion, and it's common ground that the appellant was a relative of the sponsor in this case.
Yes.
My second point concerns what my learned friend said about paragraph 29 of the judge's decision. So this is where the judge at the end said that the appellant, the sponsor during the period in question, was providing minimal support to the appellant, and the majority of the support was provided by Mr. Falk Ahmed. Now, can I respectfully invite my lord and my lady to look at paragraph 21 of my skeleton in considering that particular submission. I dealt with that particular point there. And I've made a submission that there is no requirement in law for the appellant to show that the sponsor was paying for majority of the overall expenses. So there's no requirement to show that the appellant is wholly or mainly financially dependent. Paying for someone's food may well be minimal, but that is a material support for essential need.
If that's right, it still only covers the third year of the 3-year period.
That's right. Yes, from 2010
still
to
be a
2011.
difficulty about 2008 to 10.
Recognize that, of course.
Yes.
But that is my submission as to paragraph 29. Now, my third point concerns the submission that Miller and Friend makes as to whether education in principle can be an essential living need. He very fairly accepts that in principle, education can be an essential living need. But he says that the judge below made the right decision at paragraph 32 when the judge said that the appellant in 2008 was capable to study or work overseas. Now you have my submission, which I'm not going to repeat, that a person's ability or capability to find work or to travel overseas is not relevant. But may I also ask the court to respectfully look at paragraph 13 of the judge's decision as to why it was important, particularly important for him to go to university. Last sentence of paragraph 31. He needed to go to university in order to obtain a qualification that would then enable him to come to the UK. And essentially, and after the arrival in the UK, he essentially joined the sponsor's household. I'm very, very grateful. These are my 3 points in reply.
Thank you very much. We're grateful to both of you, particularly for being so clear and concise. We'll reserve our decision. We'll send out a draft in the usual way. 2 things about that, though they're very well known to counsel, but I still have to say them. Firstly, when the draft is sent out, not for the case to be re-argued, but only for typos and obvious factual errors to be pointed out. Secondly, it's confidential to the parties. That includes, obviously, the appellant, and on the Home Office side, the legal advisors and those who need to know in order to be able to give instructions. The form of order should be capable of agreement, or failing that, written submissions on that or any ancillary matter. There will not need to be an oral hearing before the formal hand down, which will consist of publication on the National Archive and so forth. Thank you all very much for your assistance.
What was it?